90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Our special guest today is Elon Weinreb. He's an attorney and an experienced arbitrator and mediator. He's been involved in the fields for many, many years. He does represent clients in mediations and arbitrations, and he also acts as a mediator and arbitrator, and he's very experienced in those fields. In these times, Elon, why don't I let you tell our listeners, in these times when we're dealing with COVID, especially in the court system, why is this an especially good time to consider mediation or arbitration?
Well, mediation and arbitration both have moved into a larger discipline called ODR, online dispute resolution, as opposed to ADR, which they both are, which is alternative dispute resolution. And online dispute resolution in both modalities, meaning mediation and arbitration, and I'll define what those are later on, allows for many, many, many efficiencies due to the technologies which are involved. For example, people no longer have to travel to various locations in situations where you have family mediations and one party and the other might be very adverse to each other, or even involving situations of domestic violence. ODR allows for those types of mediations now to occur because the parties are in different rooms. There are tremendous uses in terms of the technology. Right now, listeners can't see this, but I'm actually sharing a screen of information. In addition to that, the cost is substantially much lower, not just because of the other factors involved in terms of traveling and what else, but because there are a lot of the preparation that's done for the mediation can be done in advance, and as well as the fact that people can do other things during downtime during mediation that actually saves them a significant amount of money. So there are many, many, many different advantages, plus also the speed in terms of the overall process. That's the same with respect to ADR as well. Both arbitration and mediation are much faster at resolving disputes than traditional litigation.
Let's go through some of your points just a little bit slower so we can emphasize them for our listeners. Litigation normally takes a long time, and it's very expensive to resolve your issues, whether you're being sued or you're suing someone. And in the past, alternate dispute resolution, or as now you call it, online dispute resolution, what had its many advantages. Why does it have even more advantages in these times when the courts are kind of a little bit paralyzed and a little bit regaining their mojo? So how does ADR, or actually a new advantage of ADR, compared to the old-fashioned court system?
Okay, well, in terms of the courts particularly, the first and the biggest right now advantage of ODR is in situations where you have a case in which a jury can be involved. Trials by jury right now are something of an endangered species. They were an endangered species even before all of the COVID-19 pandemic started, but now they're particularly endangered because of this whole social distancing requirements. And it's going to be some time. There have been some developments towards trial by jury in New York, but there have been very few and far between, and it's going to be some time before we get juries fully back. That also means that there's a backlog. And right now, there's a huge backlog of cases. So if you had a case in which you were gunning for a jury and you're waiting to get a jury even in March, now your best shot is at best probably a year from when you started. And that's just for getting the jury. So that's,
and the jury may not be the same as it used to be, because we may have jurors in remote locations.
That's correct.
We don't know what that's going to look like.
And then, of course, there's the whole issue of whether or not the CPLR and various other statutes and rules and regulations can be reinterpreted to allow for virtual appearances, whether the rules require an in-person appearance. It's not really for this program, but there's actually a dispute right now with respect to depositions as to whether or not an in-person appearance is required under the CPLR with respect to depositions, or whether, based upon other provisions of law, that the judges and parties have the right to force a virtual appearance.
And that brings us to another reason why ADR or ODR should be considered in these times, because the procedures in the court system, even before you have your day in court or get to a jury, are still being evolved, and they're more complicated than ever before, and the courts are more backlogged than ever before.
Yes. And it's going to continue that way for some time, even though I have to say the courts have done a phenomenal job at using various platforms, particularly Skype for Business. And then people now are going to be finding that it's going to be evolving to Microsoft Teams later on. It's going to happen within the next year or two, based upon what Microsoft has said. But they've been doing a great job at trying to keep things moving. They've never officially fully closed, if you look at the history, but nonetheless, they certainly took a hit in terms of being backlogged, especially with, as we were talking about before, cases of trial by jury.
And even the courts are moving toward ODR or ADR, arbitration and mediation, especially mediation, as a way of resolving disputes, because they know they work well. And many disputes can be resolved through ADR, and it's to the advantage of each party to consider ADR, whether they're doing it through the courts, doing it through you, or an ADR provider. So what are some of those advantages? Let's say to the plaintiff, defendant, to the lawyers.
Okay, so to answer that question, it would be helpful for us to define the two basic ADR processes that merge themselves into ODR, and those are mediation and arbitration. So to understand the advantages, let's get the definitions out. Mediation is a process in which a neutral third party, that's the mediator, works with the parties to reach a mutually agreeable settlement of their dispute. In contrast, arbitration involves an arbitrator, that's a person who's a neutral decision maker, just like the mediator, or a panel of 3 arbitrators, if the parties wish, acting like a private judge, hearing testimony, receiving evidence, and then rendering a binding award. Both of these processes have advantages when they're conducted in the ADR format or the ODR format as now, because the role of the decision maker is such that in the case of either mediation or arbitration, the parties as well as the decision maker have their control of their own schedules. They can do proceeding whenever they want at any time. I actually had a mediation where I had parties in different time zones, and it worked phenomenally well. We ended up actually resolving this dispute in a total of an hour and 40 minutes. That was a $90,000 amount in controversy. A case like that is tremendous efficiencies over traditional litigation. And in addition to that, there's just the ability of the parties to, again, have much more control over the overall process. You're not beholden to the rules of a judge, and to a certain extent, based upon whatever prior agreements they've had, they can tailor the process as they see fit. So those are the two biggest advantages that you have right now of ODR.
From what you were saying, it sounds like these processes, whether it's ADR or the new ODR, are much more efficient than the traditional court system, and they provide the parties and their attorneys with a lot of flexibility.
Yeah, and in fact, in terms of the overall rates of cases and settlement, it's useful to compare how mediation, let's say, for example, works versus traditional litigation. Traditional litigation, the general statistics are, the last time I checked, approximately between 90 to 93% of cases are ultimately resolved before going to trial, by settlement, by summary judgment. The statistics for that means that you're not actually going to get to a trial 90 to 93% of the time, whereas in mediation, you have very similar statistics. According to materials from David Abeshouse, who's one of the mediators with the Nassau County Bar Association, as I am, mediation is highly successful with more than 85% of mediated business cases resulting in settlement agreements. So on one hand, you have 85% resolution rate dealing from mediation, at least in the commercial field. You have 90 to 93% coming from the litigation perspective. The difference, of course, is time. In mediation, it's very rare you're going to have this extensive discovery beforehand. Certainly, if the discovery is going to be informal. So you're talking about a much faster resolution in terms of the time window than when you're dealing with litigation, and you could be going through years of discovery and then motion practice, and then even potentially when you're dealing with complicated cases, moving things into summary judgment. And
not only time-consuming, but very expensive to both sides. I just want to remind our listeners that you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island. And if you missed any portion of this program, you can listen to you can tell someone else about it. The podcast is at nccradio.org. Elon, and you were talking about the practical difference in results, but also there's the process, how people, especially with mediation, you're trying to make both sides happy or happier than they would be if it went to a jury verdict or a judge dismissed the case or found for one party or the other. You're trying to come up with a resolution that both parties can live with. So chances are both parties are going to be happier, or at least one less unhappy than they would be with a verdict from a judge or jury.
Well, that's correct. And generally speaking, it's always there's some wisdom from mediators and arbitrators as well that the best cases are involved with both of the sides being at least a little bit unhappy. I personally don't believe in that. But in terms of being, I think instead of happy, maybe use the word satisfied. I think there's going to be greater satisfaction in terms of using the ADR/ODR now we have in processes, certainly than litigation, because again, less is less up to chance. I mean, at the end of the day, when you're dealing with a judge, you're always rolling the dice to some degree, no matter what your position is going to be. And to a certain extent, you are with an arbitrator as well. Mediators, on the other hand, the difference, as we said before, mediation is a non-binding process. So you're not rolling the dice at all. If you come to either a potential resolution that you want to get into completely, or you can walk away from the process. It's completely voluntary in that regard.
And also the arbitration, you could make it non-binding. So you ultimately have the right to ignore the decision.
Yeah, it's just that in that particular case, the agreement has to be particularly structured to state that it's non-binding. The only thing about non-binding arbitration is that it's not that easy to have the parties agree to that. What might be a better alternative to non-binding arbitration is something which is a middle or a bridge process between mediation and arbitration called early neutral evaluation. And when I was defining before ADR and ODR is to comprise just mediation and arbitration, it really shouldn't be just mediation and arbitration. There are other processes that fit along the spectrum of ADR and ODR. One of the other ones is collaborative dispute resolution. But one of the other midpoint processes that we're talking about is early and neutral evaluation, and that was developed by Judge Wayne Brazil out in California. He came up with a process of having the parties essentially brief their cases, argue them effectively before a neutral evaluator early on in the case. That's why they call it early neutral evaluation. And then having that evaluator come to some sort of decision as to how the case would pan out. And then, of course, that's non-binding.
It's right. So recommendation, and both parties can continue their discussions, perhaps with the help of a mediator from that point.
Correct. Or even
I think the difference is that the court system is geared to win or lose scenarios, and there's going to be a winner and a loser. The ADR or the system is geared toward low cost resolution and finding a solution that both parties can live with.
Yeah, I agree with that up to arbitration. In arbitration, you're going to have a winner and a loser. It's just basically going to be much more efficient than you would be for a judge. But in arbitration, at some point, the arbitrator takes control. And that, of course, deals with issues of arbitrability, and that's a whole nother 10 shows if you want to do that.
But sometimes with arbitration, you can ask for a 3-panel. You can have an arbitrator you believe is going to represent your interest. There are different ways to carve out the arbitration process. You can also have a high or low to protect yourself, which you might be able to do in a traditional process.
That's
but
correct.
The true happiness, the more flexibility is the mediation system, which, as you point out, can be highly successful in most disputes.
Yes. In fact, if you envision a spectrum where on one end, let's say we'll call it the left end, you have negotiation, and then moving towards the right end, you'd be more extreme in that. You would have litigation all the way at the far end of the spectrum. You have the dispute resolution processes having an inverse relationship between the amount of party control and the amount of cost and as well as time. So, for example, in negotiation, you're going to have the most party control, and if the parties can resolve the dispute, you're going to have the least cost and least amount of time spent. On the flip side, going to the far end of the spectrum, you have litigation, where you're going to have the least amount of party control, and you're going to have the most time and the most cost expended. In between, you have, after negotiation, mediation, followed by early neutral evaluation, and also somewhere fitting in there is collaborative dispute resolution, where the lawyers get together and discuss the case. That's usually also can be done with a mediator as well, in more advanced form. And then in addition to that, you have arbitration moving closer to the litigation side. So early neutral evaluation and collaborative dispute resolution are sort of the midpoint of that spectrum.
So I think another way of looking at it, alternate disputes resolution versus the traditional court model, is that you have the arbitrator or the mediator has many more tools in their toolbox, and many more tools are available when you choose some type of alternate dispute resolution.
Yes, and that's another advantage as well, particularly in mediation. In mediation, you could have resolution of disputes through extra-legal or let's say non-legal means. Non-legal makes it sound like it's illegal. Obviously, you can never have it illegal. But what I mean by extra-legal is remedies that would not be provided by the courts. For example, this is a case actually which is recited by Marilyn Genoa as the current chair of the Nassau County Bar Association. She had a case in which the parties resolved a civil dispute through the provision of flying lessons. One of the parties happened to be an expert pilot, and the other party wanted to resolve the case by taking flying lessons. They thought that was a good compromise, so they came up to an arrangement where instead of a traditional monetary payment, one provided flying lessons for the other one became a pilot, and you had a win-win resolution there insofar as the economics were adjusted. You can't do that in a court. There's no court that's ever going to give you an injunction or an order or any sort of judicial relief which requires the one party provide flying lessons unless, of course, there's a pre-existing contractual relationship. But it's not going to be provided as a matter of course.
So I just want to remind the listeners, you're listening to Elon Weinreb. He's an attorney. As you've heard, he's a skilled mediator and arbitrator. He also represents parties, one party or the other, in mediation or arbitration, as an expert as to why these alternative dispute resolution proceedings are much more flexible, cost-effective, and faster than the traditional court system. And as you mentioned, Elon, a mediator can be creative and fashion some dispute that both parties can live with or are happier with, rather than all or nothing approach in traditional litigation.
Yes. Absolutely. And in fact, I'm actually a co-chair of the New York County Lawyers Association's ADR committee. We just completed an advanced divorce mediation training that was taught by Professor Bob Collins, in which he described a lot of the family dynamics which were involved in terms of mediation. In fact, that's what divorce mediation really is involved with, although he prefers to call it separation agreement mediation, because you don't really mediate the divorce, you mediate the separation agreement leading to the divorce. But in the course of doing that, there are a lot of things which the courts really, they can get involved with, but ultimately at the end of the day, they shouldn't. A judge should not be deciding, ideally, custody arrangements or parental visitation arrangements. He doesn't prefer the term custody. Or alternatively, how parties are going to be dealing with their own familial arrangements. Yeah, economics and money and distribution, okay, the courts can deal with their formulas for that. But in terms of the dynamics going forward, especially when you have children involved and you have other third parties who are relevant to the marriage and how that's going to go into the future, the courts don't want to spend time policing those types of arrangements over and over.
And even on the financial end, one party or the other may be unhappy with the way those are decided, while a mediator can try to carve out some agreement that both parties can live with, as well as those more important issues of child custody, pet custody, living arrangements, and preserve what's left of the positive relationship between all the parties and give them a chance to rebuild it, rather than being scarred by an adverse decision from the courts.
Correct. But there's one point there, Ken, I just want to bring a nuance to. The mediator does not set the terms for the agreement. The mediator very well might be a scrivener at the end of the day. And the divorce/separation agreement mediation that we're talking about before, what would happen is that the parties will come up with terms that they find to be agreeable. And then what will happen is that effectively the mediator just acts as a scrivener by using his or her legal knowledge to reduce that understanding to a writing. And then that ultimately proceeds within the courts. But at the end of the day, the mediator does not impose the terms. He or she could certainly be helpful in having the parties do that. But keep in mind, the mediation is a process in which the parties themselves are mostly in control, and the mediator acts as a facilitator to help them. So they're the ones who are really doing it, not the mediator.
And also, just to drive the point home, they have to approve it. Each party has to approve it. And in many mediations, they have an attorney to advise them, to advocate for them, and to maybe to review the ultimate agreement before they both sign off on it. So yes, depending on the subject, the stakes involved, parties can have attorneys with them and to act as their advocates and spokespersons in the mediation and especially in the arbitration proceeding.
Yes. In fact, actually, in terms of arbitration, just to get into a little bit of a legal discussion, Article 75 of the CPLR provides certain aspects of the traditional litigation process that litigators are familiar with, for example, cross-examination, the idea of having notice of certain processes, discovery. But they provide, the Article 75 that provides that a lot of the traditional aspects of the litigation process can be waived. The one which cannot be waived is the right of a party to have his or her counsel present. So that's something which is extraordinarily important. Certainly parties do not need an attorney to proceed in mediation. Arbitration, I would say effectively they do. A party who's proceeding in an arbitration without an attorney is really operating at their peril, much as in litigation.
And also, if the party feels they're intimidated by the spouse, by the business owner, by someone they feel has a lot of power, it's very important they have an attorney to act as their advocate.
That's correct. And that applies in all phases. And by the way, even applies even before mediation, even in negotiation. Sometimes you have attorneys who are hired as settlement counsel, even in the context of a traditional litigation, and they're the attorneys who go into a mediation, or they're the attorneys who just go into a negotiation without a mediator. And the reason why they're brought in is because they're a fresh pair of eyes as to the dispute. They're not so entrenched. And sometimes that particular strategy, having a second attorney, even though it can cost a little bit more in the short term, it pays off big time in the long term, because with that fresh perspective, you can resolve the case.
Part depends on what the stakes are, because a typical consumer may not be able to afford all these attorneys out there. I just want to remind the listeners, you're listening to Law You Should Know on 90.3 FM, the voice of Nassau Community College. If you missed any portion of this program or want to tell someone else about it, the podcast is available at nccradio.org. Are many attorneys encouraging ADR, or they feel it's going to hurt them because they're going to lose money? They have a self-interest in dragging out the litigation and billing as much as possible.
That's a great question. The answer is yes and no. It depends where the attorneys fall on the spectrum. There are many attorneys who fall into both capacities as mediators and arbitrators themselves. That's one side of the equation. On the other hand, there are a whole bunch of attorneys who, like you said, Ken, feel that there's going to be a drop in revenue for them. That's why ADR for them sometimes is described as alarming drop in revenue as opposed to alternative or appropriate dispute resolution. And so there's no one answer. It depends really how much experience the attorney has.
Well, it's also up to the client to advocate it, and the attorney may have an obligation to, when one side proposes ADR, the other attorney may have an ethical obligation to mention it to the client, but the client should really consult with someone else or there's little harm, as you pointed out, in saying yes to mediation. There's little harm to the client. The harm may be to the attorney's billing capacity, but it really is going to help the consumer, the party, have a better experience in the long run.
Yeah, I mean, overall, generally speaking, most cases are suitable for mediation, but that's not to say that all cases are suitable for mediation. There is a whole bunch of people, particularly Gene Ginsburg is one of them, and David Abeshouse is another, who describe ADR, as I said before, as appropriate dispute resolution. There are sometimes certain cases where parties are completely irrational, other cases involving, let's say, domestic violence, certainly criminal cases, where mediation is not going to be appropriately used. But overall,
or whether allegations of abuse, or both parties are definitely don't have some kind of balance of power. Elon, we're just about finished with this portion of the program, explaining the ADR process and certainly the benefits of alternate dispute resolution. Just give us your website and your so that someone can learn more about having you as an arbitrator or mediator or an advocate to them in the ADR process.
Sure. So my website is www.weinreblaw.com. That's W William, E Elephant, I Igloo, N Nancy, R Robert, E Elephant, B Boy, LAW law.com, weinreblaw.com. My phone number is 516-620-9716, located in Garden City, and I welcome any and all inquiries regarding ADR.
And I'm just going to spell it out simply. It's WEINREB law.com. And as you've heard, that Elon knows a lot about the benefits of mediation and arbitration. He's worked in these fields both as an advocate and a neutral, deciding the dispute or guiding the parties on a path to resolving their dispute, business or other dispute, for many, many years. We will be interviewing him on other shows, so please continue to listen to Law You Should Know on 90.3 WHPC. And if you missed any portion of this program, you can look for the podcast at nccradio.org along with other podcasts of Law You Should Know and podcasts of other programs from WHPC. Elon, any final thoughts, very briefly, on why ADR should be considered in most disputes?
ADR overall is more time efficient, cost efficient, and party friendly than traditional dispute resolution modalities. And that's basically what it comes down to. It's just much better for everybody who's involved, from the lawyers to the clients and ultimately to the judicial system, to the judges, and society as a whole.
Okay, thank you very much. And I would like to thank Elon Weinreb, an attorney and also an arbitrator mediator, for being our guest on Law You Should Know. Please join us next week at this same time for another program on Law You Should Know.
.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. We have with us Elon Weinreb, who is an expert on alternate dispute resolution, which consists of arbitration and mediation. And he's going to share with attorneys and the general public some tips on how disputes can be resolved through alternate dispute resolution. So, Elon, let me hand the mic over to you and just start giving us some overviews as to how parties and attorneys can use ADR to their advantage.
Okay, so I'm going to give you just basic background in what's now called ODR, which is the evolution of ADR. ADR stands for Alternative Dispute Resolution. ODR stands for Online Dispute Resolution. It's a subfield of ADR, but it's become much more prominent now in light of the COVID-19 pandemic. And the tips I'm going to give you today relate both to ADR and more specifically to ODR. But generally speaking, from the ADR perspective, even before we get into specific tips for ODR, which involves more technology than anything else as being a new variable, in ADR, the best tip that I could give any attorney to maximize the advantages of the processes, which are both time efficiencies and cost efficiencies, and spoken about this before in a previous show, is preparation. There's no substitute for it. Prepare, prepare, prepare. In fact, Jerry Spence tells litigators in his book How to Argue and Win Every Time. I have to also be a litigator, so I do this as well. Prepare until you have become the argument. And it's great advice. It's the same thing here, only the difference is that in mediation and to a certain extent in arbitration as well, you're not focusing so much more on a argument perspective or a position perspective as you are on needs and interests. In arbitration, this is closer to litigation. There is more of a position focus, but you still want to keep the needs and the interests of the clients and as well as your adversaries, if you can, involved. So at the end of the day, preparation, 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 there's no substitute for that. Now, specifically when dealing with ODR and the efficiencies which are involved, the main efficiency, of course, is technology. People don't have to travel. There's less time involved in preparing and exchanging documents. All of the documents can be exchanged before, which is another tip. If you have any relevant documents, please provide them to the mediator well in advance. And it's extraordinarily useful if the mediator has a background and doesn't have to learn the case on the fly. Otherwise, you would probably have a need for additional sessions. If it's anything which involves a contract or anything which involves some sort of document, it's absolutely essential you get the documents exchanged. That can be done by email. That can be done by central repository. You could use Dropbox, again, assuming you take appropriate steps in confidentiality, making sure that all your files for your client, and as well as treating the confidential material from an adverse party, are kept in confidentiality.
Okay, is it also going to be helpful to the mediator or the arbitrator if each party submits a quick summary of the nature of the facts and the law
Absolutely.
involved in that dispute?
Yeah, in most disputes which are complicated, I mean, obviously there are certain disputes where that's not necessary, but in more involved disputes, especially commercial ones, there should be what's called a pre-mediation statement or a mediation brief in the mediation context, which is submitted. The court rules, if you're dealing with court annex mediation under Part 146, they actually require this document.
And you also want to have a cover letter or a little brief so that the arbitrator or mediator understands your position.
Correct. I mean, in an arbitration
interpretation of
context,
those documents.
yeah, in the arbitration context, the arbitrator has authority to require actual full-fledged briefing. That's why I'm not mentioning specifically a pre-arbitration statement. You could come up with one, but in an arbitration, it works to a certain extent more like traditional litigation in terms of the procedure in that regard, and that if the arbitrator wants a specific issue of law briefed, he or she can argue it unless by some rare circumstance the arbitration agreement prohibits the arbitrator from doing that.
And many parties are weary of arbitration because it could be binding and they may not want to commit themselves, but they are willing to take a step toward ADR by agreeing to mediation.
That's correct. Yes. Mediation gives the parties a perfect escape route. If they don't like what's going on, they can look. It's like scuba diving. If you ever do scuba diving, you could look up, reach up, and go to the surface. If you're doing open water diving, when you first start learning it, anytime that you want. You can't do that when you're doing deep sea diving because of the bends. And in that aspect, that's the analogy to arbitration. Once you get down farther into the process, as you descend further into the depths of dispute resolution, and then you can't just look up, reach up, and get out whenever you want. But in mediation, you have that option.
Let's focus on the mediator for a moment, and you are an experienced mediator. What are the initial steps that you're going to use, the initial tools to try to get those parties to an agreement?
Okay, well, the first thing that you have to do as a mediator is get to know the parties way in advance, or their attorneys for that matter, but way in advance of the actual mediation session. You never want to go into a mediation session cold. Sometimes you have no choice. If you're dealing with, let's say, a Part 137 program mediation, it's not easy necessarily to contact the parties in advance. It's not always done. But on the other hand, usually speaking, when you're dealing with mediation, you want to certainly interview counsel and the parties in advance, have a call with them, and especially with ODR. And so that's why I'm going to give you, some tips also now with respect to ODR for mediators both and as well as advocates. And these tips are extraordinarily useful, making the process both more efficient and more satisfying to everybody involved. So the first tip is familiarizing yourself with the technology. Mediators should certainly do this. Right now, your listeners can't see it, but I actually have these tips shared so that you're seeing them at the same time right now, Ken. And if you were having a pre-mediation conference regarding this topic or anything else, let's say it was a legal malpractice case, as whether or not these tips were followed, you'd be able to certainly see it and appreciate it. So that's one of the features of technology. Certainly familiarize yourself with it in the format. Do it in Zoom. Don't do it by telephone and then have everybody come into Zoom. Do a tech check. The mediator being involved, obviously, as well as the attorneys, certainly at least the attorneys and the clients. And by the way, it's essential that be done.
We have a lot of ground to cover, so I don't mean to cut you short, but you also want to find out early on, and each party wants to alert the neutral early on if there's any special issues of discovery or of arrangements or anything or the nature of the dispute.
That's correct. In testing out the technology, you would do that at the same time. If there are issues which need to be resolved substantively, that's a good time to do it as well.
I'd like to remind our listeners you are listening to Law You Should Know. Our guest is Elon Weinreb. He's an attorney in Garden City, New York, and he also is an experienced mediator and arbitrator. He also appears as an advocate in disputes that are resolved through mediation and arbitration, and also, of course, through the courts. If you missed any portion of this show or want to hear other shows involving Elon or any of our other guests, please go to our podcast at mccradio.org. Elon, just to move fast forward to the dispute, how is the mediation or going to start out?
Okay, so in terms of the process of itself, it's really up to the parties because mediation is a party-driven process. So if the parties decide amongst themselves who wants to start first, it's not like litigation where there's a set order where you have plaintiff, defendant, and then ultimately the parties have a certain closing order at the end of a trial in terms of making their closing statements or even to a judge. It's very much driven by the parties' process. But to summarize the entire mediation process quickly, there's an acronym called BADGER, and it was derived from Professor Joseph Stolberg. It's found in Taking Charge of Managing Conflict at page 58, but also Professor Leela Love from Cardozo uses this in speaking about mediation mediation informally. The acronym again is BADGER, like the animal. The B stands for beginning the mediation, meaning you come up with an introductory statement and you lay the ground rules for how the parties are going to interact, which they have to agree to. The A stands for you accumulate information. That means you take your case statements, what the parties' positions are, and then you're going to try to move them towards needs and interests from those positions. As a mediator, it's much useful to focus on them for reasons I'm not going to get into now. D, as in dog, stands for developing an agenda, meaning the issues to be discussed. That includes the needs and the interests of the parties. From there, you move to G, which is generate movement or options, meaning that the parties are going to be coming up and brainstorming there with various ideas for how they could potentially resolve the dispute. And then if you are asked as the mediator to give what's called a mediator's proposal, sometimes you can step in there. But again, you want to try to have the parties do the G part themselves. E stands for escape to caucus. Caucus is a private session where very often people think this is shuttle diplomacy, where the mediator goes between one party to the other party in various rooms, which you can do now with technology in breakout rooms in Zoom very easily. And then the E, all the reasons for caucus breaks down to you want to explore settlement options, signal some sort of warning signs if you feel there's a power imbalance, confirming movement. A is attack the recalcitrant parties' positions in terms of giving them a reality check. Sometimes parties are completely unrealistic. It's more of an evaluative mediator tactic. P, pause just to take a break from the mediation, and E, evaluate. That's what escape breaks down to. Again, evaluating is done as always a last resort, usually in mediation, but it can be effective. And R is then finally, at the end of the day, once you've done all of that, resolve the dispute, have the parties come to an understanding, then potentially reduce that understanding to a writing, but better yet, have the party, or if the parties have attorneys, specifically have the parties' attorneys do that.
Okay, I just want to focus on the G and E because our time is limited here. If you are the mediator, you've heard the agenda, you've heard the nature of the dispute, and some parties, of course, may feel more comfortable talking to you alone in private. And this way, and also if you feel, do you feel it's a good idea for the mediator to give them some feedback as to how to come closer to a resolution in that private caucus?
Yeah, if depending upon how things go, that's the mediator's job. But again, it's the idea is to try to get the mediation parties, the parties who are involved, to do that themselves. The mediator is a guide.
But what if they're afraid of showing their bottom line, or they want you to give them a suggested straw they can offer to the other side?
Yeah, if they say that and you feel comfortable in terms of the way you're going in, again, you have to, as a mediator, be impartial. So it's important to make sure that you're always appearing to be impartial and appearing to be neutral. But if you could do it in such a way that you're not giving them a suggestion based upon their direct interests, but instead you're saying, this is something you might want to consider, or this is something which is out there in terms of the variables. For example, right now, cases involving medical malpractice, when you have doctors who are going to be involved, let's look at the environment pre-COVID to post-COVID. Now, doctors, and for the most part, are heroes, and they should be. They are. I mean, it's not just a perception; it's the reality. They're doing tremendous work, and we're grateful to them. But at the same time, it implicates our understanding and how we treat them. And in terms of the dispute, that could very well be a factor going forward in terms of the.
Well, certainly to a jury, but yeah. So you're going to the parties are going to give you. One party says low pay, and the other party says they want a lot of money. How are you going to develop some movement?
In that particular case, what you could do is have the parties go through what's known as risk assessment, where you would set up what's called a decision tree. It's a diagram which can show whether a party is going to have a certain percentage of an outcome. It basically deals with probabilities as to how parties' case can be evaluated. You take the sum total of the probabilities and work backwards from what could be a final outcome. For example, in the appellate division, when we do cases like that, we work from the possibility of a remand and a full trial. We work for the probability of that going all the way back to where the case is right now at this point. And then you mathematically analyze each one of those variables so that you could adjust the party's expectations.
Do you think there's also a process where the advocates, let's assume the attorney, are educating the mediator about those numbers, about their strong points based on the facts of the law? At the mediation, is each party trying to educate or influence the mediator to the merits of their position?
Well, that's going to happen no matter what, but the trick is, of course, for the mediator not to be spun. I mean, that's a very dangerous situation, is where you have a mediator ultimately crossing over to decide in terms of his or her understanding of the case, which side is right. The mediator should never be doing that. That's something which is very important. Educating is one thing. Certainly you want the mediator to be educated and you want him or her to understand all the variables, what's going on, but you never want to put the mediator in a position where you're sort of turning them because then it's no longer a neutral, impartial process. Then you have essentially an advocate who's been assumed for one side, and that's not good for the process at all.
Is it best to start with one point or one subject or one aspect to see if you can generate some agreement on that issue?
Yes, that's the concept known as partializing. It's actually one of the techniques that Bob Collins uses and is part of his program, or alternatively known as divide and conquer. It could be used in many different ways. You could take one particular large issue, let's say family dynamics and family mediation, and then break it up as to something very specific, such as how holidays should be treated, and then put everything aside, especially if you think as a mediator that that's an easy area to resolve, or alternatively, if you think it's a difficult area to resolve. It really depends upon your take of the situation, and there's no hard and fast rule for it, but as a tactic, it's very useful.
Do you also try to do that with the facts in a commercial dispute, or let's say a negligence, a tort dispute?
Well, the facts is sometimes it really depends upon the case. I wouldn't say so much we do that with the facts, but with individual causes of action. For example, if the parties can agree on the commercial side that if X, Y, and Z occurs, then there's no, I would say, legal basis for claiming causes of action 4, 5, and 6, because they would then, in those circumstances, would be duplicative. You could do it that way as well. I wouldn't say you necessarily do it with the facts, because the facts have to be taken as a whole, usually most in commercial cases, but you could do it with the legal contentions.
What other strategies would you suggest to the neutral to try to bring the parties to yes?
Amongst the other tips that you have is something called log rolling. Log rolling is a tactic in which you essentially trade something of low value to one party for something of high value to the other party. And by doing that, you get the parties to ultimately see that they're getting the most value. The trick in getting the parties to yes, which is also the name of a book, very famous negotiation book, William Ury and others, trick is to try to get them to feel that they're getting the most value and ultimately getting what they want. And if you do that by log rolling is a great way of doing that. You're giving something of low value from one party to the other party, which they consider to be of high value. And that is something which works very, very well.
And also behind that, you're getting one party to give up something they don't, that is of low value to them, but of high value to the other party.
Correct. Right. Exactly. That's what ends up happening. So, for example, if let's say you have 3 classes of assets, you could have a house, you could have a business, and then you could have, let's say, some personal property separate and apart from both of those. If the personal property has sentimental value to one party, that's going to be putting it into the high category. If, let's say, the party really doesn't care so much about the business aspects of what's going on, you have that in the low party. You could trade one for the other. Sometimes that will be very effective because then the parties feel that they're getting their value for what they want.
And how do you eventually move to other issues and try to bring the parties closer?
All right, that's ultimately based upon getting the parties talking. Because when you have, as I said before, positions that very often parties come into, the problem with positions is that they are very static. And what do we mean by a position? Let's say a person says, I need to have this particular property in this particular location. I need to have that. I can't either be forced to give it up, or alternatively, I need to be able to acquire it. One way or another, it has to be in my possession. The problem with such a stance like that is that there's very little variability. If on the other hand, the party says, I need to own real property somewhere, or I need to just be invested with value, I need to be sure that I have at least this amount of money to be able to send my kids to college, that's already a need. And then you have much more variability. What assets does the other party have? Can we work with something? Can we adjust something? Let's expand the pie. That's what you want to play with, what are called expansive negotiation variables as opposed to distributive negotiation variables. And that's the way to ultimately get the parties to yes, is to break them out of their position prison and start to let them see that there are many more options which are available to them. The more options you have, the more versatility you have. The more versatility you have, the greater the prospect of resolution.
Okay, we're going to come back to your strategies in a moment. I just want to remind our listeners, you're listening to Law You Should Know on 90.3 FM, the voice of Nassau Community College in Garden City, New York. We're talking about strategies for a successful mediation, or perhaps an arbitration as well. Our guest is Elon Weinreb, and he is a mediator and arbitrator and also acts as an advocate for parties in traditional court setting or in a mediation or arbitration. If you missed any part of the show or you want to hear other shows about the law, please go to our podcast at nccradio.org. Elon, you were talking to those discussions about various issues of great importance or where there can be room for movement. Should they take place separately between the neutral and each party, rather than getting one party emotionally upset, listening to it, and maybe they've already discussed these issues without success with the other party directly?
So that's what we talked about before with caucus. And generally speaking, yes, those are situations when you want a caucus. When you have to do risk analysis, as we said before, when you're dealing with the decision trees and getting percentages, you almost always want to do that in caucus. Unless the parties are extraordinarily mature and very even-keeled in terms of their positions, and you're dealing with people who really are focused more on the needs and the interests at the time, it's very rare when you're dealing with that type of dynamic. Unless you have a situation like that, which I've only really seen once in my entire career, then you want to have the parties in caucus in separate rooms.
And also, when you're doing the caucusing, do you want to speak to the attorney alone, or you want to speak to the attorney with the party?
That really depends upon the situation. If you have a client, a party who is particularly emotional at the time, sometimes it does certainly help to speak to the attorney privately, because then you could tell the attorney, look, you have to tell your client that maybe it's something that he or she doesn't want to hear, but ultimately sometimes these are the facts on the ground, and this percentage is probably going to be higher or lower than what you originally might have thought. Sometimes, however, you want to have the client there because sometimes they feel that you as the mediator may very well be ganging up on them by speaking inside their presence. There's a certain amount of psychological tension and apprehension that goes on whenever you call a caucus.
And that's very important to help reduce that tension, for the neutral to reduce that tension and know how to reduce it, such as I'm sure you do. Do you also want to give the attorney, let's say, a heads up and then talk to the attorney about whether the client wants to hear the bad news from the neutral or the attorney wants to convey it to them?
Yeah, I mean, in terms of the process itself, usually speaking, the attorneys are savvy enough to know, based upon emotional cues or just based upon what's said, and even just based upon watching body language, that it's time to call a caucus. And you tell the parties that at the beginning as the mediator in your introductory statement. You tell them anytime you want to break, it's not a deposition where there's a question pending and then you can't take a break. Anytime anyone wants a break, anytime somebody wants to call a caucus, you call a caucus. That's the way it works. It's a voluntary process. So
it's good to let the attorneys and the parties know they're in control to the format or how things will evolve in this dispute resolution.
Yeah, and to save time, what I do as part of my practice, and I think most mediators do as well, is certainly in the commercial context, they put into their agreement various ground rules. And in those ground rules that we were talking about before, you explain what options the parties have. So aside from just the ground rules which are more prohibitive or restrictive in nature, like not interrupting a party when a party is talking, so the mediator has a privilege usually to override that, the other ground rules are that the parties are vested with the ability to call a caucus whenever they want. They have the ability to ask questions and explore any topic as long as they're not attacking another party personally.
So you as the neutral are running the proceedings, you're in charge, but you're giving the parties more of a voice and more control of the proceedings. It's certainly something they would not have in court.
That's correct. The parties' goals in the mediation ultimately are to advocate, as well as their attorneys, they advocate for their various interests and needs. The goal of the mediator is to facilitate the resolution of the dispute or exploration of those needs and interests towards that end, but more importantly also to safeguard the mediation process, and for that matter, if you're dealing with arbitration, the arbitrator has that duty as well, is to actually safeguard the process itself. The integrity of the process, the quality of the process is of paramount importance, so that always has to take precedence.
We're running out of, we're short on time here, but as the mediator, you've resolved some issues, you're moving on to others. Is that how you generally do it? Go from issue to issue and save the toughest for last, or put the toughest in the middle?
That depends upon the parties. Sometimes it's very useful to start with an easy issue first. It's almost like chipping away at something which is more of a problem, like a sticker. You're peeling a sticker from a envelope, and you need to move from one envelope to another. I like to think of that analogy because you have to move very slowly. You can't just rip the sticker right off because it'll be completely destroyed. What you have to do is you have to very, very methodically move with something, and that's the analogy over here. Start with something easy. Do that slowly. Get agreement on that. Move the sticker up. Get some progress. Let the parties see the progress. Once the parties see the process, that starts snowballing them, starts motivating them because they have that agreement and they can move forward. On the other hand, sometimes parties come around and they say, let's deal with the elephant in the room first. I want to get that off my chest. I need to get off my chest. I can't think otherwise. If that's the case, you deal with that first.
Okay, and also, is it okay to have a timeout or an adjournment so that each party can sleep on it or do some research if they need to do it about certain numbers or certain other information, and just continue at a later date?
In some of the ODR guides, I mean, I have one which I'm showing you on the screen. You have a tip to build that into the process itself, where you want to take frequent breaks. There's something called Zoom fatigue, where people are involved in Zoom conferences the entire day, and that in itself can get them, never mind just the emotional aspects of the dispute that are going up. So sometimes you want to just build breaks into the process. And and certainly there's no requirement that a mediation, unless the parties have a specific requirement or a time factor, but there's no requirement of the process itself that a mediation has to be accomplished within a specific time frame.
Okay.
Ken, I want to close just by giving some quick tips on ODR, online dispute resolution, that's been evolving in light of COVID-19. And just to go beyond those tips which I gave before, first, you want to raise any sort of possible interruptions to your technology in advance. If there's people who have dogs or kids in the background, it's very important that they address those before mediation sessions occur. The other thing is you want to respect everybody's privacy and confidentiality. So you want to make sure that there's nobody who's going to be from a third party attending a mediation session or an arbitration session, and certainly no recording or coaching of answers in an arbitration. And finally, always have a plan B. You should always agree in parties in advance about what to do should you have technology failures, because especially in the summer with thunderstorms and what else, they're inevitable. They occur at a regular basis. The only guarantee that I certainly can give to anybody is that at some point in any given mediation or arbitration conducted by ODR, something is going to go awry or something's going to go wrong, and you have to know how to deal with it.
Give us your contact information again.
My firm name is the Weinreb Law Firm, PLLC. You can find it at www.weinreblaw.com. The W is in William, E in elephant, I igloo, N Nancy, R Robert, E elephant, B boy, LAW.com. Phone number is 516-620-9716. And I'm in Garden City.
Elon is willing to answer a question if you have about the mediation process or a particular aspect of mediation. As you also have heard through these programs, he's an expert, both arbitration and mediation. Certainly because of COVID, they're another tool to resolve legal disputes. If you missed any portion of this program, you can find the podcast at nccradio.org. We've only given general information, but if you want to use ADR, make sure you tell your attorney that, and if the attorney is not willing to consider that, perhaps consult with another attorney. Please join us next week at the same time here on 90.3 WHBC, the voice of Nassau Community College, for another program on Law You Should Know.